The competition is on. Usually by mid-morning break, we've had at least one of the speakers come in under the 6 minutes. At this conference, we have had no one so far, so Andy Rady has told me that he will beat the 6 minutes. He says they speak faster in London and more succinctly than they do here in Toronto. So want to introduce Andy Rady to talk about avoiding poorly worded bail conditions for an accused.
Thank you. Even with the pause delay here, I'm going to take hopefully not so much time. Get me out of here. I don't care what it takes. I want out. Do whatever you have to do. I don't want to spend another night in jail. You know, I've got a baby being born, and I've got a job to go to. I've got classes to attend. I've just signed up for this new program. Get me out of here. I'll agree to anything. How many times do we hear that? All the time. And what do? We agree to a lot of conditions, and afterwards we think to ourselves, why did we agree to that? Terrible bail conditions that put our clients in more jeopardy than they were in the first place. Why? Because a lot of the conditions are badly worded, badly thought out, because we do have the pressure to get them out, and we do it all the time. But we need to think more about that, because we really don't want to have our clients sitting there again in custody, facing the charge under Section 145, knowing that it's going to be more difficult to get them out, when we would have taken a bit more time in the first place to try and craft a bail condition that's going to be more acceptable. Section 515, sub 4 of the Criminal Code sets out the kinds of conditions that we normally would see in any bail situation. It's the governing section. The problematic sections in Section 515 are 4D, E1, and F because of their broad wording. And 515, 4F uses the term "and other reasonable conditions." And that's where we usually get into trouble. And that phrase, was considered by Justice Lemaire, as he then was, in a case called Keaney, which is cited in my paper. And he talks about reasonable condition. It must be related to a purpose that would otherwise justify the detention of the accused pending trial. For example, the offense occurs at 3 o'clock in the afternoon and the Crown wants a curfew. Why? Why would we agree to something like that? Why would we have a curfew when we really don't need to have a curfew, when there's no reasonable it's not a reasonable condition. There's no connection to the offense at that time. Carrying bail papers while outside, and there's a case called Williams. We see that. It still happens. There's cases, actually, both sides of that. But what is the connection to the offense that the client has done to carrying bail papers? And I don't know about you, but a lot of my clients, they have trouble carrying anything in their pockets, let alone bail papers. And most of the times they can't read them. Why do we do that? Why do we let that happen? We have to be careful about that. We have to be sure that the bail conditions are not unduly onerous. And we also have to ensure that our clients can comply with those conditions. Why set them up? Why have an alcoholic client who you agree is going to abstain from alcohol? It's ridiculous. We do it all the time. We have to be careful about that. Now, the Crown will ask for that kind of condition, or they'll ask that they not attend at licensed premises. That sort of makes sense, but we have to take care there as well. Because now, licensed premises covers almost anything. It covers arenas, theaters, ballparks, and even Pizza Hut. An incredible restriction on the person. So even if they're in the licensed premises, even if they're not drinking, they may fall afoul of that condition. So let's be careful about those kinds of conditions. We've seen justices of the peace or Crown say, well, then let's just have them not attend bars. Bar isn't defined anywhere. I mean, a lot of us have bars in our own homes, so we could probably be restricted from those. There's a bar in the courtroom. It's not precise. We have to be precise in our bail conditions. Curfews. Curfews, as I've said, should only be imposed where it relates to the offense. But what we don't do a lot of the time is ask our client about what else are they doing? What time do they work? What time do they go to school? What time do they have to get up to go to work? So is the curfew actually workable? So do we need to have that caveat added to curfews, which would say an exception for the purpose of employment or for attending school, depending on where they might be. We have to ask our clients a lot of these questions, not just accept from them, I want to get out of here, so we don't set them up. Territorial restrictions, requiring an accused to remain in the province. Same situation. What if they have business that is conducted outside of Ontario, perhaps in another province or perhaps in the States? Should there be an exception to that? Passports, surrendering passports. A lot of clients have two passports, a Canadian passport and the passport from the country from which they initially came. We should make inquiries to determine whether or not they have two passports. What does surrender your passport mean? Canadian passport, or does it mean the passport of the country of origin as well? We have to be careful about those kinds of conditions because, again, they can set clients up for breach. Youthful accused who have curfew conditions. We also see the condition unless in the accompaniment of their parent. I've got clients who have 6 parents because they're not sure or on any given time. We have to be careful. Perhaps it would be better to name that particular parent. Again, the more precision we can give in the bail condition, the better it is for the client, so they will know exactly what they have to meet. We also have, in some cases, territorial restrictions on where the client can be in a particular town or city, not to be within this block because that's where the criminal activity takes place. That's where all the drugs are being sold. Clients agree to that all the time. What they forget about is that they might actually live within that area, or that their lawyer's office might be in that area, or the courthouse might be in that area. We have to ask our clients these kinds of questions so that we know if we're going to need a restriction for that kind of a condition before we go ahead and agree to it. And that's similar to when we're dealing with attending near where a complainant lives. You know, not to attend within 3 blocks of the plaintiff's residence, or the complainant's residence. They may not know where the complainant lives. There's the time. I thought I could do it, but I couldn't. We need to know the answers to a lot of those questions before we agree to them. Just in closing, non-communication, again, that was spoken to earlier on the paper on family law. Again, that's a difficult area because the person might beat up his spouse doesn't mean he's going to beat up his children. So why are we agreeing to a condition which says he's not to have contact with his children? We have to be careful about all of those things. In order to avoid poorly worded bail conditions, we must be aware of our client's circumstances. Inadvertence can result in the imposition of an unduly onerous or vague bail condition that leads to a breach charge and further detention. We must ensure that our clients understand their bail conditions, and this requires that they be clear, unambiguous, and reasonable. Thank you.
Thank you, Andy. It's time now to move on to Ottawa and to say good morning to David Paciocco, who's going to talk to us about preliminary hearings. David, where are you?
Morning.
There you are.
Preliminary hearing, for those of you who haven't been paying much attention, has been under fairly serious attack for a long period of time. And that attack is motivated in part by the desire to save costs and make the system more efficient. Also, it's been motivated by a desire to try to make the process more simple for those who have been identified as vulnerable witnesses, sexual offense complainants in particular. Back in 1994, this attack occurred in the form of making access to summary conviction trials easier for the Crown and more palatable by increasing the penalties. Recent amendments, which have just come into force under the Criminal Law Amendment Act, have taken a new approach. The primary goal is to make the preliminary inquiry more efficient, but there's a subsidiary impact on the potential fate of the preliminary inquiry that I think we have to pay close attention to. Effectively, there are 3 strategies used in the most recent attack. The first strategy deals with changing the election requirement for preliminary inquiries under Section 536. The second strategy is to try to narrow the issues that are dealt with during a preliminary inquiry. And the third strategy is to change the rules of evidence that apply during the preliminary. So these are very important changes. First, dealing with the election requirement under Section 536, having a preliminary inquiry will no longer be the default position. It's not the case any longer that your clients will have to waive the preliminary inquiry before one will not be held, and the Crown will be required to show a prima facie case. In fact, there's a requirement now that the party seeking the preliminary inquiry must request the preliminary inquiry at the time of election. Now, to be clear, this is not an application provision. Initial proposals were that you had to justify having a preliminary inquiry, but uncharacteristically effective lobbying by the defense bar put that to rest. But it's still necessary to bring the application and to request the preliminary inquiry before one will be held. The expectation is that this will reduce the number of preliminary inquiries by putting an onus on us to make a careful choice about whether we feel one is required and to turn our mind to the nature of that preliminary inquiry. Obviously, there has to be concern for underrepresented or unrepresented accused persons who may not get the benefit of a preliminary inquiry because that legwork is not done at the outset, either through ignorance or lack of motivation. The second strategy to make the preliminary inquiry more efficient is to try to reduce the number of issues. The first method used is, again, the request process. It will not just be a simple matter of you standing up in assignment court saying you want a preliminary inquiry for your client. You will have to make an application in the sense of spelling out exactly what witnesses you want to hear from and what issues you want to deal with. There will be rules of practice developed and practice directions in terms of how these requests will be made. The potential problem with this mechanism, though, is that obviously you're not going to be in a position to make these decisions until you have full disclosure. So the irony can be that we're going to be more insistent on assurances that we have all disclosure before we make our determination as to whether to have a preliminary inquiry and what form of preliminary inquiry it will ultimately take. The fact that you can identify the issues and the witnesses you want to hear from does not, in my opinion, give you the right to tell the Crown what witnesses to call at the preliminary inquiry. You have the power, of course, under Section 541, subsection 1 and subsection 5, to call your own witnesses at the preliminary. So you're simply describing the scope of the prelim for the ultimate judge conducting it. The second method of trying to narrow the issues is the preliminary hearing to the preliminary hearing. The opportunity for the judge assigned to conduct the preliminary hearing to order a prior hearing in an effort to try to narrow the issues. The judge can do that on his or her own motion, or it can be done by application of either the Crown or the defense. The problem, of course, is that practically we tend not to assign judges early to preliminary inquiries, and under the particular provision it is the judge conducting the preliminary inquiry who has the power to do this. Of course, courts are pragmatic, and I think what's going to happen is that you're going to see judges simply using the ordinary pretrial process to try to vet these issues. I don't think we're going to see a lot of pre-hearings to preliminary hearings. Everything that can be done there can be done in the ordinary course. Judges, the third method of cutting back the scope of the preliminary is for judges who have been now given a duty to control the proceedings, whereas they've always had the power to limit questions that are considered abusive, repetitive, or inappropriate. The section now imposes an obligation on them to do that. This will have absolutely no effect. Judges control this already, and certainly it wouldn't be a jurisdictional error not to do this. It's essentially a message to judges to try to be more careful. But the most significant of all these changes, in my opinion, is the provision that is going to allow inadmissible evidence to be tendered during the preliminary inquiry. Worded much the same as Section 518(1)(e) of the Criminal Code dealing with bail hearings, judges at a preliminary hearing are permitted to act on evidence that they consider to be credible or trustworthy, even though it may not be technically admissible. The process is for the party wanting to put in a witness statement, for example, to notify the other side, and for the other side, if it opposes the use of the document rather than the calling of the witness, to bring application to require the witness to be produced. This raises a number of questions. First of all, in direct evidence cases, it would put an end to the preliminary inquiry if you could simply file a witness statement that sets out that the offense has been committed. It would undermine completely the discovery process, hence the significance of this provision. I make the argument in my paper and more extensively in the Criminal Law Quarterly review article that's referred to in there that the term credible or trustworthy should be more analogous to the con reliability standard than to the practice that takes place in bail hearings. A critical question is who has the onus when it comes time to try to subvert the ordinary process by using documents rather than witnesses. The classic position would be he who brings the application has the onus, which would be the party who wants the live witness. However, don't forget Section 540 subsection 1 of the code, which requires the justice to have the witnesses testify under oath in the presence of the accused. In my opinion, that means that the party seeking the document is going to have the onus of establishing why they do not want to bring forward the live witness. At the end of the day, this is going to depend on the attitude of the justice conducting the preliminary inquiry. If they believe in the discovery function of the preliminary inquiry, they will be reluctant to use this power. If they don't, then they may be quite prepared to endorse these types of cases, and as a result, many of the preliminary inquiries that are now being held are no longer going to be possible. Don't
1 minute,
forget that
David.
even after this is over, if a judge refuses to, or permits the documents to be tendered, there's still power under the criminal code for defense counsel to call their own witnesses. And I think you should give careful regard to whether you have this option in the event that the Crown tries to conduct the preliminary inquiry without the key complainant. Thank you.
Thank you, David. Now call upon Peter to talk to us about plea negotiations.
As I say in the paper, I believe that preparation is the key to striking the great deal for your client on the matter of sentence. All of you can recall situations when you've been in court, hopefully it hasn't happened to any of you personally, where defense counsel on speaking to sentence is constantly turning their head and speaking to their client about the information that they should have received from the client at the initial interview. And the reason they're doing that, I call it rubbernecking, is because they have not done proper preparation. I believe that good preparation begins with the initial interview with your client. You're supposed to get as much background information as you possibly can during that interview. If there's things that the client can't remember, send him away with a list of things that maybe you write out for him so that he can go away and get that information for you. Once you get the disclosure, it's your job to review it in detail, but many counsel don't review it with their client. So they have no idea where it is going to be a guilty plea, what facts your client may be prepared to admit to. And that, I submit, is extremely important for you to determine at an early stage. From the disclosure, you should be looking for mitigating as well as aggravating factors involved in the case and the facts, and you should be discussing those with your client. You should be asking about potential witnesses that maybe the police did not interview that support your client's position as to what the facts are that may mitigate the sentence. You should determine what potential weaknesses there are in the Crown's case. And where you've made the decision that the Crown can prove the case and your client wishes to plead guilty and giving you those instructions, those potential weaknesses may become a leverage that you have during your meetings with the Crown and trying to get the Crown to accede to your position. I believe that it's important where there's going to be a guilty plea to have some conversation with the investigating officer to determine what position they're going to be taking on sentence, and perhaps through your discussion with that officer, get them on side so that they support the position that you're going to take, and that may make your job a lot easier when you come to speak to the Crown at the pretrial. I think it's extremely important at an early stage of your preparation to come to some sort of understanding of what your goal is in sentencing, because that will dictate to you the types of materials, the types of things that you need to be looking for. Don't be afraid to be innovative and creative. I think a lot of defense lawyers, when they come to the matter of sentence, leave their brains outside the door sometimes and don't really try to think outside the box. Innovative sentences can result in a much better result for your client. You should be looking for lesser included offenses. You should be looking for alternatives to guilty plea. You should be looking for provincial legislation that may be appropriate for the allegations that are made against your client. I've set out in the paper in the materials that some of the materials that I put together for judges and crowns and that I would try to support my position. Community service may be something that you want your client to start even before you've walked in through the Crown's door to talk about sentencing. Getting them involved in counseling, getting medical letters if they have medical issues, character letters, employment letters. I've set all that out. You as defense counsel should be actively involved with the psychiatrist or the psychologist or the addiction counselor or the family counselor. There should be phone calls made. You should have contact. You should write letters outlining the things that you want them to address in their reports to you. And in some cases, you may even want to meet with these professionals because you may be calling them on the sentencing hearing. At the Crown pretrial, I think that many defense counsel don't realize the advantage that they have. Crowns often get their files the night before, or in some cases the morning of. You know the case better than the Crown. You have your client's input as to what happened, and you have reviewed the disclosure in detail. And the Crown, in many instances, won't know anything about the file at all, and maybe having only read the synopsis. So you're going to also know the mitigating circumstances, which the Crown won't know because the police don't generally put any of that inside the materials that they uncover during their investigation. And you are able to put a positive spin on your client's involvement in the offense. I often try, where it's possible, to approach a specific Crown, if it's a sensitive case, where I want to be putting forward perhaps something that's a little innovative or creative. And I will approach a Crown that I've got a relationship with where they respect me, I respect them, and we're able to have that kind of discussion. I think it's extremely important to work out the facts during that Crown pretrial. I've seen so many counsel in court over the years who, when they arrive for the guilty plea and for the sentencing, they're working out the facts with the Crown as they are standing on one foot. You should have resolved that way in advance. You should write them out yourself. When you and the Crown are talking about the facts, you should be the person who writes out the agreed statement of facts to then provide it to the Crown. Don't let them do it for you, because there'll be all sorts of amendments and all sorts of things that you want to change. I guess the last thing that I'll say to you, everything else is in the paper, but I think a lot of defense counsel don't realize that you don't just have one shot at the pretrial. This pretrial can continue over several pretrials, and I've had numerous situations where a Crown has given me a knee-jerk reaction at the first time that we've met, and as a result of reports that I provided, character letters that I've provided, perhaps some case law, the Crown's position starts to soften. And I find as time goes on and we have further pretrials, and then we may involve the judge in the judicial pretrials, Crown's positions where initially they're looking for jail ultimately result in something like a suspended sentence. And don't forget about section 625.1, sub 1 of the criminal code. A lot of times the Crown will say, look, we've agreed on what's going to happen. We don't need a pretrial, or they'll say, we haven't agreed, but we don't need a pretrial. Well, you have the right to ask for a pretrial, and that section gives you that right, and I think a lot of defense counsel don't know about that. That's all I have to say. Thanks a lot.
Thank you. Next, we'll hear from Heather McArthur, who will no doubt provide a bookend to Janet's presentation for Disclosure Part 2.
All right, so disclosure. Everybody knows Stinchcombe, and everybody knows the law, that the Crown has a constitutional obligation to provide full and complete disclosure. Okay, that's the law. Everybody knows from a practical point of view that what we determine and what we believe we need for disclosure and what the Crown attorney thinks that they should provide are often two very different things. Now, disclosure is very important in terms of a well-drafted disclosure request, and also diligently, zealously, and as we all know, very often repeatedly, over and over and over again, requesting what would seem to be fundamental, basic disclosure. But it's imperative, because of all of the other issues that you've heard about today and the other issues that you will hear about, to have these requests and to make sure that you continue to follow up on the requests, because it ties right into 11B. It ties right into costs from the Crown. It ties right into possibly getting stays of proceedings. So it's very fundamental. But we all know as well that on a practical level, that there's often more and more creative arguments being advanced as to why we shouldn't get certain disclosure. And there's also what I sort of see as the black hole, where you send letter after letter after letter in, and it seems as if nobody gets them, or nobody's read them, and certainly nobody cares about them. But at the end of the day, it's important to do it. getting back again to 11B, to costs, and to stays. So what should you ask for? Certainly, one of the first things that you need to request is the notes of all police officers. And I think that in respect to this, and in the materials, my materials, like Mr. LaFontaine's, Greg's, are sort of at the front of the binder, but there's a disclosure checklist that I've attached there. But I think that the police officer really points out what seems to be happening now is that the Crowns really are simply giving core disclosure as opposed to full disclosure. So once you receive the disclosure, you have to go through, make sure that you have all of the police officers, and if there's officers who are on the periphery or seem to not be all that involved, make sure that you request those officers. Because at the end of the day, the officers who are on the periphery of an investigation can often provide the most valuable information, especially if you have a situation where there's Section 8, Section 9, credibility issue with the officers. The ones on the periphery might not have been told what the plan is, what the game is, and often you can find some real truth in their notes that are incredible in setting up inconsistencies. All civilian statements, of course, request that. On a larger case, what you often find is that you'll get some of the civilians that the Crown and the officers think are key, but you won't get all of the other civilians that are mentioned, so you have to follow up on those. Again, because those who the Crown Attorney and the police think are not important are often the ones who provide the best defense for us. All video, audio statements, of course, it's really important to ask for that right at the outset because there's a number of Crown Attorneys and a number of offices who take the position that they won't give that until a date has been set for trial, which just boggles the mind because how can you be in a position to set the date for trial until you've reviewed those audio and videotapes? So make sure that you put that in the initial disclosure requests. Again, criminal records of all civilian witnesses, we're absolutely entitled to that. The Crown Attorney often takes the position that they won't give it. It's clear that it could be relevant and they should be giving it. The same with outstanding charges. The same with occurrence reports with respect to any civilian witnesses. Now, I'm sure many of you are aware of the decision of Justice Clark, came out in December. It's the case of Stiles. In that, he determined that occurrence reports relating to civilian witnesses fell under the parameter of third-party records, such that an O'Connor application had to be brought. Okay, once again, with the greatest of respect, kind of boggles the mind. But there it is, and the Crown Attorneys are proudly brandishing that, saying we don't have to give you occurrence reports. On Tuesday of just this past week, Edward Sapiano got a decision from Justice Keaney relying on the case of LAT, which says the police have to have an obligation to give to the Crown, and the Crown has an obligation to obtain all relevant information. Relying on that, he says, well, look, of course, occurrence reports are not third party. They're in the possession of the police. They're clearly relevant. They must be disclosed. A copy of the endorsement, I've left it outside on the table, and also Kathy Castilda, who's running the program, has a copy as well. So if there aren't enough copies outside of the endorsement, you can contact her and she can get you a copy of it. Because they're outside, I believe that it's Corey Eisen, but the endorsement is outside. It's June 2nd, Justice Keaney. Now, another area that can be quite helpful, particularly if you have a Section 8 or Section 9 argument, or if you have some kind of credibility assessment with respect to how the arrest took place, are the mobile data transmissions, or MDT transmissions, as well as the radio communications, so everything that's going on during the course of the arrest. This can be also really important with respect to any number of issues. For example, identification. One case that springs to mind is all of the officers said that they were looking for an individual who was dressed all in black clothing. However, once the radio communications were obtained, it turned out the person that they were chasing before they wrote up their notes was dressed all in yellow. That was, absolutely essential in getting an acquittal. However, the Crown Attorneys often say, we're not going to give it to you for all sorts of things. It's not relevant, it's privileged. Work product is one that I've heard. A useful case to refer the Crown Attorney to is the recent Court of Appeal decision in Brown, and that was the racial profiling case. Because in that case, the Court of Appeals said MDT transmissions are the type of evidence that could support a finding of racial profiling. So right there in the Ontario Court of Appeal, they set out why MDT transmissions are relevant. The booking video, again, not all police, for example, in Newmarket, they don't have the booking video, but many do take booking videos. This can be absolutely essential, again, in terms of identification, what your client looks like when he or she arrives at the station. Also with respect to any 10B, because there's often things on that booking video that don't make their way into the officer's notes. Again, an example, when the client is being let off screen and you hear him saying or her saying, well, when do I get that free legal aid you've told me about? That can get caught, as well as nonverbal. So you have the right to a counsel, would you like a counsel? And they nod. That's on the video, that's not in the officer's notes. So again, it's absolutely essential. The area, and I'm almost out of time, but a very significant area that's come up is to what extent we can obtain information with respect to the misconduct of police officers. By and large, the case law has suggested that these are, in fact, third-party records that we have to bring an O'Connor application to get. I would say, again, it does boggle the mind. Now, there is some support now for defense obtaining this material from the recent Ferguson report. And Justice Ferguson, in Volume 1, Part 1, sets out a recommendation with respect to 5 areas that we should be able to obtain, including convictions, findings of guilt, outstanding charges, any convictions or findings of guilt under federal or provincial statute, and any finding of guilt for misconduct under a Police Services Act, as well as any current charge of misconduct that's been gone to notice for hearing has been issued. So in terms of dealing with the Crown Attorney as to why we should be obtaining this material, I think it's quite helpful to refer to the Ferguson report. The Ferguson report can be easily obtained by going onto the internet. I actually got mine from the Metropolitan Toronto Police Services website, which I kind of liked. I thought that was nice that they were helping me in terms of finding out all of the misconduct that they're involved in. The other thing, the information in support of any search warrants and the information in support of any Part 6 authorizations. Again, ask for these right from the get-go, even if you're not sure if they've been involved, because routinely now what they're doing is they're sealing these materials. And it's essential that you ask for them at the outset, and also ask if the Crown Attorney will consent to the release of these materials and obtain them themselves. Many Crown Attorneys will take the position that it's up to the defense to obtain this material, which, and the third time I'll say it, boggles the mind, because the case law really makes it clear that this is essential disclosure. So by putting that out in your very first request and following up on that diligently, you're far more likely to get it. And if you don't get it, again, you're in a much better position with respect to 11B and stays of proceedings. Again, go through the checklist, and you have to read your disclosure. Every case is different, and there's always new and inventive things that you can think of that can assist your case. And at the end of the day, really, when you're met with this wall that you're not going to get it and all of that, it's really helpful to refer to the case of R versus LAT, which is a 1993 decision of the Court of Appeal. It's 84 CCC 3rd 90. And there it sets it out very nicely. There is a duty on the Crown to make full disclosure. And accordingly, the Crown has a duty to obtain from the police, and the police have a corresponding duty to provide for the Crown all relevant information and material concerning the case. When you start being met with this brick wall by the Crown Attorney that it's in the police and you're not entitled to it, this case can be very helpful referring to it to just gently remind them that in fact they do have a duty to go to the police and say, what else do you have, and give it to me now.
We're going to move to Windsor and hear from Pat Ducharme, who's going to talk about when to object and when to be objectionable. And of course, Pat Ducharme is a person who is never objectionable, always a gentleman, and a person who will speak on this. So we'll go to Windsor, and I hope, Pat, that Michael Gordner's there, because he told me he would be.
I don't actually see him here, but it may be just for mine that he's stepped out. Welcome, ladies and gentlemen from Windsor, Ontario. I am indeed going to speak to you about the thorny and difficult area of making objections during the course of a trial. The mechanics of how to make an objection are relatively simple. They have two parts. First, you give notice of the objection, and secondly, you state your grounds of objection. But more importantly, I think most people should consider the impact of our objections on our triers of fact. For the most part, I believe that often they are seen in a negative light. We as counsel are seen as persons hiding important evidence from the jury, little secrets that we know to be important and that by our objection we may be making some effort to conceal. In dealing with the methodology of making an objection, again, it's relatively easy to state. We always rise. We never make an objection from the seated position. We get acknowledged by the court. If for some reason the judge does not see you standing about to make an objection, there's nothing wrong with saying, Your Honor, I have an objection, and then you will be acknowledged. Your opponent should be seated. If the opponent is not seated, you do not have to put up with an opponent standing right next to you, looking at you while you make the objection. You can politely say to the court, when my opponent is seated, I will give you my grounds of the objection. After you give the concise, succinct grounds of objection, you should be seated and await the ruling of the court. When the court gives its ruling, if it is in any way negative, not granting the objection or not granting it fully, you should be stoical. You should not be anything other than a person lacking remonstration. Like the elite poker player, you accept the loss and you move on so as not to highlight the loss. When do you make objections? Well, you make objections any time a rule of evidence or a rule of procedure is about to be breached or is breached. So therefore, there's nothing wrong with making a timely objection, even during a question, if the question itself will call for some answer that's inadmissible or breaches the rules of evidence. If the question itself does not necessarily cause the problem, you should wait the answer, and if the objectionable material comes with the answer, you make it in a timely fashion at the time of the answer. Objections become a little bit more problematic during submissions of counsel either to the jury or to the judge. Counsel generally, and properly so, are loath to interrupt other counsel, particularly when they're speaking to the jury, and even so when they're speaking to the judge. Generally, we await the full submissions of counsel, and then we ask politely that the judge consider excusing the jury. We make our objections, and we let the judge deal with whether or not there's merit to our objection. You should know that there are significant legal consequences to the failure to make an objection. Generally speaking, the case law supports the proposition that an argument will not be prevented on appeal by failure of objection, but the Court of Appeals certainly may take into account the failure to object. Our courts of appeal have shown a propensity not to second-guess counsel. They won't attempt to determine whether or not counsel, for tactical reasons, didn't make an objection, or simply that counsel was wrong or inadvertently missed the opportunity to make an objection. They will generally assume that the objection was not made because counsel was not opposed to the evidence that went in. So it may have a significant impact on appeal. It may also have an impact during the trial because the position taken by counsel during trial oftentimes helps the judge formulate the charge that will be made to the jury. Why should we make objections? Well, I've discussed some of the legal reasons for making objections, but there may also be tactical reasons for making an objection. For example, you may want to interrupt or impede the flow or rhythm of opponent's case that's going effectively. You may want to give a witness of yours time to answer a question that's particularly difficult or sticky. You may want to point out some unfairness. Now, making an objection for any of those reasons alone would be considered improper. But if the objection has merit, and it's simply the timeliness of making the objection, you'll find that it can effectively accomplish those other goals. Why should we not make objections? Well, the obvious reason is that sometimes objections cast a bright spotlight on the impugned evidence. Jurors might think in the back of their minds, if counsel is so worried about this evidence, it must be important, and they may pay particular attention to it. Sometimes our failure at making an objection also underscores a lack of confidence the jury may have in us, because we object, the judge disagrees, and all the jury hears is, the judge thinks this counsel is wrong. And lastly, but probably most importantly, an objection always gives opponent the opportunity to make a mini jury address, highlighting the actual relevance and the reason or importance for the evidence. And if opposing counsel is right about that, again, it underscores or supports that particular evidence. The last thing that I want to talk to you about in the few minutes that we have is what might be described as objectionable conduct. I give examples in the paper that I've written of numerous cases where lawyers have acted in a way that would be described as lacking civility, lacking professionalism. I think if you see yourself in any of those examples or those pages, you ought to reassess the way in which you approach a case. Civility, when you think about it, is the hallmark of professionalism. And we need, as practicing members of the criminal bar, to be leaders, to demonstrate civility and professionalism every time we show up in a courtroom. The thorny area of making objections is a difficult area because it requires sometimes split-second decisions. It's a difficult area, but in doing it properly, sometimes we spell success, and in doing it improperly, we spell failure. I thank you very much for this brief opportunity to address you today.
Thanks, Pat. I'm going to ask Jane Kelly to come up and talk about something that I think many defense counsel neglect, and that is getting proper instructions from your client.
My topic this morning is getting written instructions from your client, which needs to be reiterated because there are some people who still believe that you don't need written instructions or, in fact, any instructions from your client. And I hold out as an example my father. Any of you who have been to Oshawa have probably dealt or bumped into my father in the hallway, Terry Kelly, who certainly doesn't believe you need any instructions from a client. In fact, you're supposed to tell them what to do. They don't tell you what to do, and I think he's still doing that as the federal crown in Oshawa. Speak to Bob McGee, whose client he convinced. A good dose of jail for your client would be terrific. He convinced the client before Bob got there, and in fact got a thank you note from the client after he got out of jail. Bob might have wanted written instructions in that case, but I think it was too late by the time he got there. Now, I won't refer to him as a dinosaur because I'd be insulting Mr. Cooper, who was called to the bar the same day, over 50 years ago. So, but it's just interesting to see how times have changed. Now, he has been involved in the practice for 50 years, and certainly things have changed. I think clients are more sophisticated, quite frankly. Clients are much more willing to question any advice or instructions or anything said to them by going to another lawyer, for instance, speaking to their cellmates quite often if they're in custody, speaking to their family members, etc. So you are always being questioned as a lawyer, and it is unfortunate, but the clients are sophisticated. They know that they can go and get advice from other people. And if you suspect that the person or your client is of that type, I think you should encourage them to do it, but that doesn't take away from the fact that you want to get your instructions in writing from them. Now, when I reviewed the materials from last year, I saw that David Humphrey had spoken on the same topic last year, and with his permission, I have reproduced his paper because he goes through some examples, and For those of you who were here last year, I apologize, you're getting it reproduced, but it is an excellent paper on the repercussions of not getting written instructions. Ali Benaya being a good example of somebody who didn't get written instructions, faced a civil lawsuit, and really, if he had had the written instructions, he would have been in a much different position with respect to that lawsuit. And as I say, unfortunately, we're in a day and age where we're not only battling the Crown, unfortunately, sometimes we're battling the client. And there's no point in you as defense counsel losing sleep over instructions that you want to obtain from your client. Get them in writing. So when I was speaking with David on the phone about making use of his paper, we went over a couple of things that may have changed since that paper was written, and also things that I include in the directions, which are included at tab 16, starting at 1615. In my particular direction, I asked them to acknowledge that they will, if it's going to be a conviction, that they will get a criminal record as a result. I also include in the direction that they will have some difficulty traveling to the United States or foreign countries following a plea. And a conditional discharge is a good example. Even if they're getting a conditional discharge, they may have some difficulty, even as much as a peace bond may hurt them when trying to cross the border. And it has happened to one client of mine who received a conditional discharge. When he went to cross into the United States through Windsor, he had some difficulties as a result of that discharge, called me in a panic, but at least I had had the written instructions and given him an idea that there may be some difficulty when he crossed the border. So it was not so much of a surprise. It was unfortunate, but at least I was covered in that respect so that when he called me, I could remind him. And thankfully, I had the file there and the copy of the direction at my fingertips to remind him of that at the time. I've also included a direction, the next direction commencing at page 16-17 is one of Michael Lacey's precedents for a peace bond. Because some of us, obviously, a peace bond is a great resolution sometimes for a client, but if they're involved in a family law proceeding in particular, they may have some difficulties with respect to the peace bond. And I think Michael's precedent is excellent because he goes through the conditions of the bond. He explains that it is not a criminal record, but that it will still come up on the CPIC checks and appear on police records. He also then explains that he is not a family law lawyer and he cannot give family law advice. And I think that's important to have in writing from your client because, as we all know, we often get questions with respect to family law, immigration law, those sorts of things. And I think you want to advise the client or have them acknowledge to you in writing that you're not an expert in that field, unless, of course, you are. Then he indicates what he's going to try and put on the record. And, you know, if you're in front of Judge Ormston in 112 court, you may not get the opportunity to put this on the record because we all know how busy it is. But I think it's important if you can put on the record what he has included in italics so that a transcript of that proceedings can be ordered and used in the family law proceedings should it be necessary. Of course, then Michael explains that if they proceed to trial, he's likely going to win, but Michael thinks he's going to win everything. So, but he does include, you'll see that he includes the prospect of whether or not he will be successful thereafter. But I think that's a really good precedent for a peace bond and will alert you to the problems that can arise even with a peace bond, which may be a good resolution in the criminal aspect of things, but have repercussions thereafter. Lastly, I've included a precedent about rejecting a beautiful sentence. Unfortunately, the client told me he didn't do it, so I've just included a one page at the bottom acknowledging that he rejects the plea and that he wants to proceed to trial. So I hope those precedents are of some use to you, and I thank David Humphrey for allowing me to include his paper.
Thanks, Jane.
Thank you, Jane. We're now going to move north to Sudbury. Berk Keaney will be speaking to us about interviewing a potential complainant in the domestic assault context. Hello, Berk.
Good morning, and hello from Sudbury. We've been discussing one of the issues that Greg LaFontaine raised earlier, and we've come to the conclusion that, Peter, you are the most qualified to speak on trace hair evidence. Moving on to the issue at hand. Well, you can no longer say, unlike Pat Ducharme, that I'm not objectionable. What to do when in a domestic situation the complainant wants to talk to you. This is a sensitive matter, particularly if the complainant wishes to recant or substantially qualify the statement that has been given previously. There will be suspicion, ultimately, on behalf of the prosecution, the police, that somehow the complainant was unduly or improperly influenced in giving the statement. So there is a procedure I would suggest that should be in place to deal with such a situation. One of the things that also we should recognize is that the complainant's position may change in the future from the recantation to a subsequent recantation of the recantation. Let's take a look at the scenarios under which a complainant may wish to talk to the defense counsel. One, which is rather benign, is that the complainant simply wishes legal advice of some sort for matrimonial, family law related issues. What to do about matrimonial property, custody, access. That's rather simple. Obtain your legal advice elsewhere. But I would suggest that under any circumstances, it's best not to talk to the complainant personally, and whoever is talking to the complainant should take careful notes of the interview. The second scenario under which a complainant may wish to speak is that she wants to resume communication or perhaps even reconciliation with your client by either assisting in release on bail or requesting that the bail conditions that are in place be varied. In those circumstances, where the complainant is not recanting but simply wishes to resume the communication, there are the same rules that apply. I suggest do not conduct the interview yourself, and whoever does takes careful notes. Then the complainant should be sent on to contact either the victim witness assistance program or the Crown's office in anticipation of hopefully a consent bail variation. It's a judgment call in those circumstances whether you send on the statement of the complainant. A note of caution: if your client is the subject of a non-communication order, either by virtue of Section 515.12, an in-custody non-communication order, or a bail order where they're prohibited from communicating directly or indirectly, take care that you do not become a party to the breach of that order by communicating matters. It's sometimes something easy to slip into. Clearly, the most sensitive area is where the complainant wishes to recant or substantially alter the statement which had been given to the police. The obligation, the high obligation to the client, will direct the course that you take. And my suggestion is that the complainant not be sent off to the police or the Crown for an interview. Inevitably, pressure will be put upon the complainant not to recant, even under threat of public mischief charge, and it's your duty to your client to obtain and preserve the evidence. It's critical in these circumstances that counsel distance him or herself from the statement-taking process, and I would suggest to the extent possible that the complainant be interviewed by someone other than counsel, and that the interview be recorded, and preferably that the statement be taken under oath. What counsel does not want to do down the road is end up in the witness box if the recantation is subsequently recanted. And further problematic in those circumstances is the complainant may suggest down the road, when the relationship has broken down, that they were pressured somehow into making a statement. So the template that I suggest is that the statement be taken by a third party, preferably recorded and under oath, And one of the reasons that I suggest that it be taken under oath is that depending upon how things unfold, you may be able to KGB the statement as a defense KGB statement for the truth of the contents, not simply for the purpose of challenging the credibility of the complainant. Lastly, at the outset of the interview, the complainant should confirm that they are in attendance of their own volition, that they have not been pressured in any way to come and make the statement, that they're aware of their right to legal advice prior to making the statement, and have chosen to come forward simply for the purpose of correcting a misstatement which was made earlier. Summary, summarized at the end of the paper: ascertain the purpose of the communication, ensure that anyone speaking to the complainant on your behalf makes careful, detailed notes of the entire conversation, and if the purpose of the communication is to qualify or recant the statement, never become personally involved, and ensure to the extent possible that the process is conducted in such a way so as to avoid any suggestion of impropriety on the part of the defense. And although not every fact situation can be covered, if you're guided by your high duty to your client and good common sense, things will work out for your client. Thank you for the opportunity to address you this morning.
Thanks, Berk. Going to ask David Humphrey to come and talk to us about consequences beyond conviction for drinking and driving offenses.
First, I want to say this. I'm assuming that the very generous applause that Jane Kelly got was really appreciation for the paper I wrote. On my topic, I want to start with this observation. You know, many years ago when I was deciding what type of practice I wanted to get into, I was attracted most by the practice of criminal law because I assumed that as a criminal lawyer I'd really only need one book, a criminal code. That's really all I'd need to advise my clients about the offenses with which they were charged, and more importantly, the consequences they might face. And although early on in my practice that held true, the world has really changed, and that is no longer so, at least in relation to drinking and driving offenses. Now, in advising a client about the consequences that flow from a drinking and driving charge, we have to be as aware of and mindful of the provisions of the Highway Traffic Act and its regulations as we do of the criminal code. Now, my brief paper is intended really just as an overview or a catalog of the consequences of first being charged with a drinking and driving offense, and of course, more importantly, with being convicted of a drinking and driving offense. And by drinking and driving offense, I'm capturing all manner of those offenses: impaired driving, impaired care and control, over 80, and charges of refusing or failing to provide a breath sample. And I suggest that it's critical that we as criminal defense lawyers understand the full range of consequences of a conviction for a drinking and driving offense. And of course that we carefully review those consequences, I suggest, at least at two critical stages. Now, the first is the consequences have to be reviewed in detail when advising a client as to whether or not the client should plead guilty. And second, in the event of a conviction, and this is either following a plea or following an unsuccessful trial, we have to remind our clients of some of the consequences of the conviction, and I think particularly of the Back on Track program, because that program requires that our clients take the initiative. Our clients have to take the initiative to enroll in that 11-month program and to successfully complete that 11-month program before the expiration of their 1-year driving suspension imposed by the province. Because if they don't complete that program within the year, the license reinstatement will be delayed until it's completed. But let me return to the most important point, and that is advising the client as to how to plead. Because the first thing the client is going to ask is, what are the potential consequences of a conviction? And the client has to be told that, and this is even in the case of a low-end first offense for impaired or over 80 or refuse sample, there's no accident, there's no injury. The client faces this list of consequences. a minimum fine of $600, a criminal code driving prohibition of at least 1 year that will be overlapped with a concurrent Ontario driver's license suspension of 1 year in the case of a first offense. The client will have to complete the Back on Track program during that 1 year if he hopes to get his license back at the end of the 1 year driving suspension. And that program costs $475 plus GST. The client has to be advised as well that for the 1 year following reinstatement of his driver's license, his license will be subjected to an ignition interlock condition which will restrict that driver from operating any motor vehicle unless it has an ignition interlock device in it. And the device requires that he blow into the screening device of the car on startup and periodically when operating the vehicle. And if the samples provided into the device exceed a preset limit for blood alcohol, then the vehicle will either not start on startup or will cease to operate a short time after. And the cost of that program is estimated to be approximately $1,300. And then to top it all off, your client's insurance company is going to take another piece out of them. And it's usually a big piece because following a conviction for a drinking and driving offense, insurance premiums are dramatically increased, at least for a period of 36 months. And there's a chart prepared by the Ministry of Transportation. It's available on their website, and I've reproduced it at page 5 of my paper. It summarizes the total estimated out-of-pocket costs of a conviction, and the estimated total is $13,475, and that's assuming legal fees of $2,000, which sound unreasonably low to me, but that's the low-end estimate. So when you take those hard costs and you add to them the costs and the hardship of at least a 1 year driving prohibition and suspension, one can see that the stakes are very high. So the client will naturally ask, well, what discount do I get for pleading guilty? And the answer is that the discount for an early plea really is minimal. Again, in the garden variety first offense, the client on a plea is probably going to get the minimum fine of $600. But following an unsuccessful trial, he's probably facing a fine of just a few $100s more. Okay. On a plea, there is an opportunity to do something with the 90-day administrative driving license suspension. So if one pleads guilty during that 90-day suspension, the balance of the 90-day suspension is swallowed up in the 1 year suspension imposed by the province of Ontario. But the reality is, no one should be pleading guilty to any of these offenses without getting disclosure. And you have to get paper disclosure, you have to get any video. By the time you've got all that, you've substantially served or completely served the 90-day administrative driving license suspension. So there's really very little incentive for a client in those circumstances to plead guilty, other than achieving some small reduction in the fine and maybe some reduction in lawyers' fees because pleas are cheaper than trials. And the last point I'll make in the brief time left is that, of course, this advice may be different in the case of a second or subsequent offense. We have to remember that where the Crown gives notice of increased penalty, one has to remember the mandatory minimum jail sentences, 14 days for a second offense, 90 days for a third or subsequent offense. And often the jail term can be either eliminated or reduced through resolution discussions with the Crown. So in those cases, or where on a first offense there are aggravating circumstances like a bad accident, injuries, and things like that, there may be a real incentive to consider a negotiated resolution rather than proceeding to trial. I have more to say, but I don't have more time, and I thank you for your attention.
Next, I'll ask Paul Burstein to come forward to talk about Section 9 of the Canada Evidence Act.
I'm actually kind of surprised that our paper managed to make it into the binder because I didn't, or I should say my partner Karen and I didn't start working on it until last weekend. We were sitting in my office last week working on this never-ending murder trial that we're on when a call came through to my office from one of the very helpful and knowledgeable CLE staff asking where my refreshment material was for this conference. I didn't know what she was talking about. At first, I thought she was asking me to bring the bagels and coffee that were going to be served. But the woman then said to me, "Don't you remember back in January 2004 having committed to writing this paper for the conference on Regina versus Coffin and refreshing memory?" As much as I like Peter and Andrea and certainly wanted to help, I wasn't too keen on agreeing with her suggestion that I had said that. So she says, well, she'll send me something to refresh my memory. So we're on the phone, and all of a sudden over my email, I get this picture of some pallbearers carrying a coffin in a funeral, and a video clip of like a cough syrup commercial. And I get the message, but she comes back on the phone, over the speakerphone, and she says, "Do these items refresh your memory?" And I say, "You can't show me these pictures to refresh my memory. They're not written documents. They don't refresh my memory." And she says, "Well, of course I can." And she cites Wigmore to me, saying, I can show you anything to refresh your memory. It doesn't have to be a written document. And she also, at the point, cited a case that I had lost, which I found a bit cheeky, but nevertheless, a case called SS, which stands for the same proposition. And I said, well, fine, but you know what? They don't refresh my memory. I have no memory of having said that. So then she sends me a memo of a conversation that I had or supposedly had with my office mate, Greg LaFontaine, back from early May, where we were lamenting together about having committed to writing these papers back in January. Now, shocked as I was that LaFontaine would even make such a memo, let alone send it to the Law Society, I responded to the woman, "You can't use that to refresh my memory of what I said in January 2004, because this memo, it's not contemporaneous," she said. I said, "Yeah, right, contemporaneous." And I said, "I know there's a case somewhere." And she said, "Oh, you mean the 1972 decision of the Ontario Court of Appeal in Gwozdowski?" I said, "Right, it has to be contemporaneous." She said, "No, that case has since been rejected by the Ontario Court of Appeal in later cases, in particular a case called KGB, it's a different KGB, as well as almost every other appellate court in Canada, as well as some of the British appellate courts." And I say, "Well, fine, but I didn't write this memo, LaFontaine did. So you still can't use it to refresh my memory." She says, "It doesn't matter. The law permits me to refresh your memory, irrespective of whether you authored the document." Well, somewhat flummoxed at this point of how to get out of having committed to writing the paper, I said, "Well, it still doesn't refresh my memory." And she says, "Well, let me try something else." So up on my email pops an email that she's forwarded to me. It appears to be something that I sent, dated January 14th, 2004, to Peter and Andrea, thanking them for the opportunity to participate in the program and telling them how forward I was looking to being able to do the research and write the paper. And she came back on the phone and she says, "Well, would you have written this email if it wasn't true?" And I said, "Well, no, I guess not, but I still have no memory whatsoever. I got nothing upstairs about that the email can refresh my memory, and you can't use the email to prove that I committed to doing this." And she says, "Oh, yes, I can, because it's your past recollection recorded." And I said, "Well, that's fine, but you can't prove for certain that I wrote this email. Anyone in my office could have come in here and written this email." Well, frustrated at my seemingly growing hostility to her request, the woman starts cross-examining me at large. She starts saying, "You've accepted, you've agreed to participate in this program on previous years." I say, "Yeah." She goes, "You saw the ads for this year's program in the ORs." I go, I guess. She says, "Well, you're a lawyer in Ontario. You're obligated to read the ORs." I go, "Okay, I guess." And so I cut her off and I say, "Look, excuse me, ma'am, you have no right to cross-examine me just because you claim that I wrote something or said something different. And I just happen to have this case of Williams from 1985, the Ontario Court of Appeal on my desk. And she says, look, I'm not just relying on the fact that you authored this earlier statement to say that you're being hostile to me. I'm relying on your defiant attitude to my request for the paper. Well, I assured her that my defiant attitude had nothing to do with her. It's just, I guess, being a busy and stressed out criminal defense lawyer, as well as just being defiant generally. And so I did say to her, after being frustrated myself, why don't you write the damn paper? Well, as Karen, my partner, who was sitting there listening to this conversation over the speakerphone, duly taking notes, pointed out to me, the woman already had written the paper.
Thank you, Paul. Mitch Eisen. Is Mitch Eisen?
Barry.
Oh, he's in Barrie. What am I saying? You came down last year. You got lazy this year. There he is, Mitchell Eisen. Talk to us
Thanks
about
very
searching
much.
kids in school, Mitch.
I chose this topic because of two observations that I've made in recent past. First, in our law and order zero tolerance day and age that we all battle against every day, the school authorities seem to be becoming more and more brazen in the manner in which they're policing the schools. And by way of example, up here in Simcoe County, we're now finding that they are searching the schools in preemptive searches. The authorities are inviting the police in with dogs. The kids are put on lockdown in their classes while the dogs sniff the lockers, and the kids are then brought out one class at a time, while the dogs then search or smell or sniff the desks and the knapsacks. The second observation that I've made is that while many council are aware that the Supreme Court of Canada has dealt with the issue of searching kids in schools, there seems to be a misunderstanding out there that essentially the Supreme Court gave carte blanche to the school authorities to do searches, and that Section 8's really a dead issue in that regard. And thus I called my paper Revisiting MRM, not in the sense of revisiting it as we traditionally see or talk about where can the Supreme Court change it or where can it be better, but simply revisiting it to look at it again. Because it's my view that, well, yes, it's true, the Supreme Court says that there's a significantly diminished reasonable expectation of privacy for students at schools. Nevertheless, Section 8 remains alive and at least somewhat well. The facts in MRM were fairly straightforward. The principal of the school received some information from a number of students, one of whom he had information that had been correct in the past, that the accused was going to be attending a school dance that night with marijuana on him, and that he had been selling marijuana at the school in the past. When the accused did in fact attend at the school dance that night, the principal called the police and asked for an attendance or an officer to attend, and he asked the student to come to his office. In the presence of the officer, the student was searched, and in his sock was found some evil weed. Justice Corey, on behalf of the Supreme Court, the majority, was not prepared to say that the principal was acting as an agent of the police. But he clearly did state that where the principal or a teacher is acting as an agent for police, then the usual standards respecting prior authorization by warrant, reasonable and probable grounds, will apply to both the police and or their agents. But he went further and stated, even where a teacher or a principal is not acting as an agent of the police, a charter analysis must still be undertaken. So what's the level of scrutiny that he suggests? Well, he suggests as follows. A search by school officials of a student under their authority may be undertaken if there are reasonable grounds to believe that a school rule has been or is being violated, and that evidence of the violation will be found in the location or on the person of the student searched. All of the circumstances surrounding a search must be taken into account in determining if the search is reasonable. Thus, even where it's simply a teacher searching without any police involvement, there's still two basic criteria that have to be met. First, there's got to be reasonable grounds to believe that a school rule has been violated, and usually if it's looking for drugs, presumably reasonable grounds to believe that the student is in fact in possession of drugs. And secondly, there's got to be reasonable grounds to believe that the evidence that's being looked for will be found where it's being looked for. Justice Corey suggested examples of what may be reasonable grounds. He suggested information from one credible student, or information from a number of students, or observations by a teacher or principal, or a combination of these, which the school authority believes reasonably is credible. There are two further criteria that Justice Corey suggested. First of all, the search itself must be conducted reasonably. He stated as follows: the search conducted by school authorities must itself be reasonable and appropriate in light of the circumstances presented and the nature of the suspected breach of school regulations. The permissible extent of the search will vary with the gravity of the infraction that is suspected. Presumably, there's more right to search for drugs or weapons than for a bubblegum infraction. Every search should be conducted in as sensitive a manner as possible and take into account the age and sex of the student. It should not be forgotten that the manner in which the students are treated in these situations will determine their respect for the rights of others in the future. Justice Corey also suggests that this modified or lesser standard applies to A, searches on school property, and B, searches by school officials that are within the scope of their responsibility to maintain order and safety in the school. So that's another area that's open to be looked at. If council is going to be running a Section 8 on a search in school, council must be aware of the following. Justice Corey was quite clear that a teacher or principal who's not acting as an agent of the state does not require a warrant. And he goes further and states that a warrantless search in such circumstances will not be presumptively unreasonable, and therefore the Hunter and Southern onus shift that we would normally see will not take place. But nevertheless, it's my position that we should be looking closely at these school searches because the teachers are getting more and more brazen. Thanks from Barry.
Thanks, Mitch.
And I think it beat the 6 minutes.
Next, we're going to ask David Locke to come forward to talk about the Queen and board.
Good morning. We touched on board last year, and just to recap, board came out of the Court of Appeal last February. There was an attempt made to introduce fresh evidence indicating that Mr. Board was the victim of systemic racism. The Court of Appeal did not accept in that particular case that racism could play a role in sentencing, but left the door open by saying systemic racism and the background factors faced by black youths in Toronto are important matters, and in another case, I believe they could affect the sentence. We just wanted to touch for a few minutes on the trend following that, basically to see if this statement was at all implemented in any cases. And we've really only found two cases involving 3 individuals, and they're courier cases out of Brampton. The key case is Hamilton and Mason. Mr. Justice Hill released that in February of last year. And in that particular case, it was importation of between 200 and 600 grams of cocaine. Now, as you may know, usually when you get around a kilo or so, the starting point is 3 years. In this particular case, we were dealing with, and the other case is called Spencer, and Justice Mossop released that shortly after following Hill's decision. But we're talking about individuals who are, number 1, single mothers, 2, little contact with the father, 3, they were primary caregivers to the children, 4, they lived at or below the poverty line, 5, no criminal records to speak of, and 6, all 3 women were black. Mr. Justice Hill was satisfied based on his observations, and it should be noted, and this is important, that there was no actual evidence called on this point, but he made the observation that in his experience, black women were overrepresented as couriers. That is, young, black, poor, single mothers were virtue tested, as he called it, or preyed upon by drug overseers. And for him, that was the link, if you will, connecting the background of these individuals and systemic racism. And he further indicated, and this is also important, that these disadvantaged people in their community would not necessarily be deterred by more severe sentences, i.e. general deterrence. And all three individuals received conditional sentences. And it should be noted, as we've noted in the paper, that the Court of Appeal has yet to release its decision on Hamilton and Mason, and some direction from that will be of assistance. If you look a little more closely at this case, what it really did two things. It specified a profile of the offender. And so the application of board in this case is extremely narrow, because it really only applied to black female single mothers who were vulnerable and essentially had no choice but to, in fact, become couriers. They were compelled by their position in life. And further, that the systemic and background factors played a role in the commission of the offense. Now, evidence wasn't called in this regard. He took judicial notice of it, if you will. The interesting question was, well, that's all very well for black female offenders as described. What about male black offenders? Mr. Justice Durno released a decision called GB at the end of July 2003. Now, GB was a 33-year-old man raised by his mother and grandfather, essentially coming from a broken home. He had a good pre-sentence report. He imported about 236 grams of purity-adjusted weight, if you want to, as they now call it. No criminal record. Essentially, a fellow that came from a fractured family, lived in poverty, but when Mr. Justice Durno looked at the situation, he found that he did not fit the, number one, the profile, the specific profile. Why didn't he fit the profile? Well, because he was not a primary caregiver. He had a job and had opportunities that the women in the other cases didn't. He was not a single parent. He had an opportunity to go to school and chose not to. And so Mr. Justice Durno, in fact, differentiated, and he went out of his way to say that he is not accepting Justice Hill's case because he doesn't have to, because number one, he doesn't fit the profile, and secondly, he made specific observations to the fact that there was no link, and I go back to the link because there was no link between systemic racism and the offense itself. Justice Hill said the offense of importing cocaine by these black females, he took a broad stroke and said these individuals, there's a link between the offense of importing and racism because of the position they were in. He found that. Justice Durno wanted more. He said, I am also unable to find a link between the social context issues, particularly systemic racism, and the offense. The fact that someone has financial need in itself does not provide the link which takes the offender into the category described by Justice Hill. There is no evidence from which I can infer that the offender was the victim of racial prejudice, which provides the link to the commission of the offense. So the trend so far has been extremely limited. One or two other cases of interest. A case called Bowen. Bowen was a female, black, 23, had some education and other opportunities. Justice Andre, in rejecting this same analysis, said a member of this sort of group who has been the subject of systemic racism does not automatically qualify. There's got to be some exceptional circumstances. You've got to call positive evidence to establish that link. You've got to bring something positive forward. There really hasn't been much else. There have been one or two other cases that have referred to it. Justice Andre had a case called Richardson, which essentially said this was a fellow who was in for a number of robbery offenses. At the end of it all, he made reference to board, but he made reference to it, but didn't accept it because he got around to it and accepting a 3-for-1 principle on sentence. I'm just going to leave you with these thoughts. The cases those three main cases were serious cases involving cocaine importation. The Court of Appeal has said serious violent offenses will not, you can't bring racism to the fore and hope that that's going to reduce a sentence on a serious violent case. And we tend to look at the more serious cases. I'd recommend that you start on a small case, a case where someone might be looking at 30 days, and you want to maybe get a conditional discharge for some person who's at a similar background. File a report, the Royal Commission on Racism, and put it in the judge's face. Don't just do it subtly, as we all tend to do. We have a black offender before the court. We tend to soft sell it. This may be an opportunity to put it right in their face, put it on the judge's lap. Say, here's the report. Here's a fellow that may deserve 30 or 60 days. He needs a break. He needs a conditional discharge. Look at his background. Put it right on the table. So the issue has to be addressed. I'm willing to bet more often than not, you're going to get a good result.
I'm going to call upon Dr. Joel Mayer, who is the Deputy Director of Scientific Affairs at the Center for Forensic Sciences, to come and talk to us about generating a better relationship with the Center and Defense Counsel.
Thank you. Good afternoon, everyone. Thank you for the invitation. I'm glad to be here, and I say this with guarded optimism as I look around the room. When I was first involved with this, I was informed that the title has already been set and there was not much I could do about it. I had a visceral reaction to this because my sense was that the title suggested, much like some of the TV ads, that new and improved today meant that yesterday we had old and useless. And I don't believe that's the case, and I'd like to convince you of that, though clearly building relationships is an ongoing process. The message that we share with the staff of the Center for Forensic Sciences, I'd like to share with you, is that we strive to, across all grades and functions of the Center for Forensic Sciences, to bring in a good, solid relationship with all the stakeholders in the justice system. And it really doesn't matter to us on which side of the house you sit in. It's something that we need to do. The mandate of the Center for Forensic Sciences, as many know it today, is one that produces results of scientific examinations, opinion evidence, and of course we have the client education component as well. I suspect that for many in the legal profession, and especially to criminal law specialists, the center may be viewed as a government laboratory, first of all, which has been established to assist in advancing the prosecutorial sort of activities of the Crown. That's not the case. We're not cops in lab coats, as we've been referred to previously. But in terms of our history, I think it's important to understand that we were initially established as the Attorney General's Laboratory in 1951. The name was changed to the Center for Forensic Sciences through an order in council in 1966. And then and now there was a continued and conscious effort to in fact bring in the worldview of this laboratory being an impartial scientific laboratory and not one arm of the other of any other government organization. And it may come as a surprise to you, in fact, if you look at that order in council, to find that in 1966, the #1 mandate of the Center for Forensic Sciences was, in fact, to conduct research and education. Well, that's no longer the case today, though research and education are certainly part of it. The reality is that we do produce results of scientific examination when asked to do so by law enforcement, by the legal system, and so on. The question that always comes back to haunt us, that has been answered by jurists, by the bench, and by the bar alike, is there property in the witness? And clearly everyone tells us, no, there isn't. And we like to think that that's in fact the case, and we like to behave in a manner that in fact is consistent with that. And in terms of looking at a relationship with you, any other stakeholders in the Center for Forensic Sciences, I'd like to suggest that our behaviors are driven by our own reality, and a relationship, in fact, requires that behaviors on the other side are cognizant of that and, in fact, make adjustments for that. The expert must never become an issue. The work is subject to challenge, as always, and that has been in fact, some of our reality in the last few years. And someone held up the Kaufman report I can assure you that I have the 2 volumes of the Kaufman Report on my desk, and that's almost constant daily reading, because there are lessons to be learned from that. And some of the lessons that we've learned as an organization, in fact, is to bring in some changes as a result of that, as a result of other changing realities and change management that was required. First of all, we have a fairly large quality assurance unit that looks at every aspect of the work. We've invested in staff training. We have an advisory body that is a bit of a watchdog. We benchmark against other laboratories. And perhaps more importantly, we have a complaints department. We will listen to you, we require your input, and we need to make adjustments as the input comes in to in fact look at our processes. Certainly we all recognize that the accountability of the Centre for Forensic Sciences is not only to its employer, the Government of Ontario, but to the public and the legal process, and this is what drives many of our behaviors. Relationships, partnerships require partners. And I think if I can convince you of that and convince you that in fact we are here to partner with defense lawyers, with Crown attorneys, with law enforcement and so on, I think I will have achieved my goal. It's a human process. Convincing everyone of this and making sure that it happens on the ground is a challenge. And we have to understand that challenge is something that should not necessarily translate to an attack activity. This is where staff at the Centre for Forensic Sciences gets somewhat uneasy when in fact that trial, the questions that are leveled against them are viewed as attack questions. I would suggest that rattling the witness is in fact not always the best strategy. If you have to impeach a witness, well, so be it, but let's go that route. The fact of the matter is that the state always ends up having to provide forensic science services. One of you told an audience at the Centre for Forensic Sciences, I'm rattled here, that in fact, you know, a trial is not a search for the truth. A trial is an opportunity for the other side to find out whether the allegations that the state is making, in fact, can be supported. And this is our role, to provide that. In that role, we end up producing scientific evidence, and we certainly do not want to wear the mantle of an advocate. That's not our job. And if you can appreciate that, maybe this will lead to a better relationship. We end up having to support a proposition or providing information that will reject one, but this is where we come in. Certainly 3 pressure points that we've heard of in the past that we see on a daily basis are testing. Why don't you do testing in confidence for us? Well, we cannot. I'm sure you're aware of the Regina versus Murray decision having to do with the Bernardo tapes. As agents of the Crown, we can't do that. Certainly maybe some issues of liability. Disclosure, we've heard so much about. The issues that we're struggling with are very much the same issue, and we're guided by Stinchcombe, by the rules of the profession, by what you tell us needs to be done. And certainly the issues of relevancy, third partying, employment confidentiality, and HR issues as they relate to the Centre for Forensic Sciences also go into the mix for us. But we don't create policies to create a wall or a shield. Our policies is designed to, in fact, sort of direct the traffic and control it. Opinion evidence, we find, sometimes leads to less than better relationships. Well, I tell everyone at the center that we all have to recognize where fact stops and fiction begin. That is, what are the facts? Educate everyone in terms of the facts, and then let's go on with what your opinion evidence is based on that. And this good faith basis that was alluded to earlier doesn't cut it in this business as far as I'm concerned. We have to generate facts and then clearly indicate to everyone where the opinion evidence is. The reality, the legal reality, is maybe that you have to come up with a bottom line finding of guilty or not guilty. The scientific reality is that it's an evolving type of reality. It has limitations and doesn't always answer the questions that are required, but that should not be viewed as being evasive or in any way obstreperous to the whole process. Other jurisdictions have laboratories that are known as crime laboratories, sheriff laboratories, police laboratories. The Europeans tend to have institutes of forensic science linked to universities and so on. The center, I find, is probably a mid-Atlantic solution to the whole thing, which is suggest to you that we're there to work with everyone and all the stakeholders and not just with one side of the house or the other. Our logo says Science for Justice. It's not just words. We welcome an interaction to clarify our work, issues, any questions that you have. But please remember, everyone tells us the legal advice is all these conversations cannot be privileged. We do not promote the role of an active conduit between our staff and anyone else in the process, but if asked, we will have to divulge what conversations took place, but we'll be more than happy to have you visit. In closing, our professionals joined the team in order to carry out science in a challenging arena, but not to enforce the law. We should recognize that. They're proud to contribute to the system and come with no personal agenda to this. They don't seek scientific or legal confrontation. They're just not trained to do that. And they get very uncomfortable when they're put in that situation and get caught in the crossfire. We sometimes find the legal pressures demand that we be all things to all people, and that's tough. At the very bottom, we constantly strive to create a better relationship. If we can get your input into this and help, that would be much appreciated and very useful, I'm sure. Thank you for listening to me today.
Thank you very much, Dr. Mayer. That brings us to conclusion for today's proceedings. Thank you in particular to the speakers who took the time out of busy schedules to prepare presentations. Special thanks to David Locke and Rebecca Rutherford, who helped Peter and I put today's program together, and also to Kathy Castaldo at the Law Society, who organized everything from the admin end. Hopefully the other ILN locations are enjoying the same beautiful weather that we are in Toronto, and enjoy the rest of your weekend. Thanks for coming out.